This is attorney Ryan Heath. He writes at the Gavel Project on Substack, where this issue he has covered in detail. So go follow him now. Also, a shout out to the Prescott Pulse, who has been covering this in detail. So also go follow them as well. So we initially covered the story. We will link it below. And right now, there are really three things that I want to cover in this interview in case you have not been paying attention. There's a current lawsuit. Sherry Hanna filed a lawsuit, so we definitely want to talk about the underlying lawsuit and the potential conflict of interest or the alleged conflict of interest. We want to talk about the TRO and how this case has now landed at the footsteps of the appeals court. So, Mr. Heath, welcome.
Thank you. And I'm excited to be here.
Awesome. So let's dive in. Let's talk about Ms. Hannah's lawsuit and how we even got here, how this got on your radar, how you became her attorney.
I want to be here. I don't want to have to drive up from Phoenix to talk to you. But the fact is, the people behind me don't deserve to pay my legal fees because some of you are lying. So if there isn't resolution by the end of the day today, you can expect a lawsuit tomorrow. You're going to find out why Mark Elias blocked me on Twitter. You're going to find out why Harmeet Dillon follows me on Twitter. And you're going to find out why I've spoken at 2 national litigation conferences despite being 33 years old. I'm one of the best attorneys in the state, and you're about to find out why. So just flashback to May of 2025. There is a vacancy on the Prescott City Council, and my client is one of the 3 finalists to fill that vacancy. What happens is there is a public meeting where all of the final 3 candidates are interviewed. My client happens to be the only Republican in the race. During the meeting, they had the interviews, there was public comment, and then Mayor Good stated on the record that they needed to go into executive session for legal concerns. And there's a motion, it passes. I believe one person, Brandon Montoya, voted against it. They go into executive session, and during executive session, they have a conversation wherein the city council members basically just explain to people what's going to happen on the dais once they go back to vote. And so the question during executive session is whether or not there was a conflict of interest for 2 members of the city council in particular. That would be Mayor Good and Lois Furworth. And they are members of the Arizona Republican Party as well as the Yavapai County Republican Party. And according to their duties as council precinct committee men, or precinct committee women, there was an obligation for them, an oath that they had to take that was required by the bylaws of those organizations. It was a contractual agreement they signed requiring only to support Republican candidates. And so they came back out of executive session and explained that they were going to be recusing themselves because there was a appearance bias that they had based on those particular positions they held in these private organizations. So they come out of the meeting. That leaves Connie Cantelme, Brandon Montoya, Eric Moore, and the one, Ted. These were the council members. Connie, during that meeting, explained to the members, the executive session, that she actually also had a conflict of interest. She was a member of a group called the Republican Women of Prescott, which is another private organization that has bylaws requiring its members to support only Republican candidates, even in nonpartisan races and nonpartisan elections. And so she abstained, and the Democrat who was being considered was appointed to the city council. This is a largely Republican city council. Almost, I believe actually every member is a Republican registered. And they selected a Democrat through this backdoor executive session, which is a violation of Arizona's open meeting law. And that's what we're suing over. That was the first lawsuit. I know there are quite a few proceedings here, and we can get into that, but the first case concerned an open meeting law violation and violation of the city charter as well.
Okay. And that there's been in Arizona, we've seen this down in Maricopa County where people have gotten sanctioned for, supporting people, just seat for supporting Democrats. But can you drill down on why this is different? Why it's not so much about the support and versus the way that it was done?
Yeah, I mean, nothing to do with whether or not my client was a Republican or a Democrat or an independent. What happened here is a violation of Arizona law. There are on the books that require open participation when it comes to decisions, but that the government is going to be making. And so in this case, when we're talking about an appointment of a city council member, what this really boils down to is the franchise right, the right of individuals to vote and have represent their interest in our government. So this is the people's ballot that is being delegated to the city council. There are two particular provisions of the Prescott City Charter which deal with this. If the vacancy within a certain number of days from the next election, then there will be an appointment through the vote. So the people actually have the right to vote for who will fill the vacancy on the city council. But under the circumstances here, because the appointment was further out from the next election, it was left to the city council to select, it was a delegation, who was going to be filling that vacant seat. And so this comes down to our most fundamental right, and that is the right to the franchise, the right to vote. And that's why we are in the court in here to strictly apply our laws to make sure that we're not selecting who is going to be making the laws under which we as good citizens must live in smoke-filled back rooms, which is exactly what happened here. And that's why we're suing. We're just trying to make sure we're not even suing for damages. We're not suing to ensure that my client gets the appointment. We just want a fair process because that's what the people of Prescott deserve.
And quickly after, a second lawsuit was filed, and that lawsuit, if I'm correct, was based on the representation and how the city paid for the representation. Can you explain that?
Yeah, so the way the law works, when you file an open meeting law complaint or a claim against a city or a government agency, there has to be a public vote to appoint or at least to hire representation outside counsel to represent the entity itself. And now the problem with this is that we sued under Arizona's open meeting law, which allows us to bring a claim for declaratory and injunctive relief against the individuals that they violated the law. This could result in them having to individually pay the attorney's fees in this case, as well as possibly removal from office, which is something that we're going to be amending our complaint in the trial court to include in the prayer for relief, because we want to clarify for the court that is actually what we're asking for. So when they had this meeting, there was a meeting on October 20th, after we had filed the suit on October 15th. And in this meeting, it was a public meeting to retain a firm called Pierce Coleman out of Scottsdale to represent the city in the first lawsuit. Now, the problem with that is because we sued all of the individual city council members in their personal capacities asking for equitable relief, meaning declaratory or injunctive relief about the open meeting law violation, they have a pecuniary interest, a financial benefit when they voted to approve the contract to hire Pierce Coleman to represent the city. And that actually has been played out in the first lawsuit. The problem here is we have a law 38-503, which is the conflict of interest law under Arizona statutes. And it's if you are going to financially benefit or benefit in your property rights as a public official, you have to recuse yourself from that vote. So because we actually sued all of these people in their individual capacities, whatever arguments that Pierce Coleman is going to be making on behalf of the city, and they actually have extended these arguments to represent the interest of the individual defendants, those are going to financially benefit them because they're not going to have to hire their own attorneys, these individually sued council members, to represent their interests. I can tell you, I mean, my time is it's very expensive to hire an attorney like myself to litigate these types of issues. And these individual council members are benefiting to the tune of tens of thousands of dollars. And that's why we filed the second lawsuit, because we should have won by default in the open meeting law case, given what happened.
And you went in for the TRO, and the TRO was initially denied, even though from reading your article on this, it seems like it wasn't denied because you didn't have a valid claim. Can you explain that to the readers? What happened at the TRO hearing, and on what basis did the court deny it?
Yeah, the TRO, we actually did a hearing on the second lawsuit. So once we filed the second lawsuit, the issue was whether or not Pierce Coleman was going to be able to get paid to represent the city in the first lawsuit. So the legal question in the second lawsuit actually became predominant over both cases, because whether or not they're going to be able to get paid and lodge arguments on behalf of the individual defendants needs to be decided upfront. So I, with opposing counsel, and we stipulated to a number of things, which were the inclusion of several exhibits to be into the record for consideration by the court. and to decide whether or not the TRO, the temporary restraining, should be granted, precluding Pierce Coleman from appearing and representing the city and the individual defendants in the first lawsuit. And so the court stated at the beginning of its order denying this that if we take allegations on their face, yes, there is a conflict. It is a substantial conflict. It's not some sort of remote conflict from which the law does not provide protection. So this actually is a valid case, but then the court went on to explain basically that there were too many questions left unanswered in the law, which is something that he was required to do. He was required to make legal findings on these things, not just punt for a later time. And that's why we appealed. So we appealed to basically the Arizona court by filing what's called a petition for special action, which is an expedited appeal. And that has been accepted by the Arizona Court of Appeals, at least for briefing. So the reason I'm able to talk today and I'm not slaving away in my office and working 14 hours is because the appeal or the response to my petition for special action is due today. So I expect to receive a copy of that tonight, and then I will be working extremely hard the next 3 or 4 days to get that final version of my brief into the Court of Appeals, which is due 5 from tomorrow.
Okay, so you got in weeds a little bit. So let's make this clear just for people that are going to watch this. When you went into the TRO, basically what the court did was they punted it because they said that there were too many issues to be decided on a TRO kind of emergency status. Is that correct?
That is right.
Okay. So it's not that you lost per se. It's just that the court was like, I can't do this on an emergency basis. We can't do it on a TRO. Let's just wait for the actual hearing.
Correct.
Okay. And why did you just want to wait for the hearing?
Well, the relevant facts, preliminary injunction, we could stipulate were basically the minutes of the October 20th meeting, which was a decision to this Pierce Coleman firm. The statements of the parties there too. We decided that those evidentiary questions could stipulated so the court could actually reach a final decision. And the reason that we appealed is because the court basically didn't reach that final decision on some of the legal questions based on the evidence presented. It's the judge said, this is something that to be drawn. There are questions left decided on the legal claims, whether or not this is possible. And so that's the ambiguity in me to believe that the best course of action for my client would be to file a petition for special action and get a decision on those questions right now. Because there's briefing going on in the first lawsuit in Hannah 1, which is what we call it. There is a motion to dismiss that was filed by the firm Pierce Coleman. They filed this motion to dismiss, making arguments on behalf of the individual defendants. So basically, this is self-dealing that we are seeing in real time. A bunch of city council members decided to use taxpayer funds to defend themselves from their own unlawful conduct, which is benefiting them financially, not only in the attorney's fees that they're saving, but the potential award against them at the end of the day with respect to my attorney's fees, which is a huge deal. So we're asking a bunch of fundamental questions about Arizona law, and we're hoping to get some decisions on those from the Court of Appeals very quickly so that we can resolve the underlying issues in Hannah 1 quickly as well. We're going to be expediting this case in the next month and a half. We're likely going to have a trial, if not before the end of the year, in early January up on these issues.
That is really fast. And please keep us informed because if you do have a trial, I definitely would like to come up there and watch some.
Absolutely.
If I'm hearing you correct, it sounds like while the court is deciding if it's even lawful, permissible for these attorneys to be in place, they are racking up tens of thousands of dollars with the motion to dismiss and various motions on Hannah, on the current lawsuit. It is important that this is decided in an expedited fashion.
And there's one more thing that I want to throw out there for the people of Arizona to understand. This is not just about Prescott. This is about our tax dollars at work. Right now, up in Prescott, the city council is deciding to allocate over $15 million in state funds with respect to renewing and remodeling the rodeo up there. So this is not just about Prescott. This is about our rights as citizens across Arizona to ensure that our government officials are not engaged in self-dealing with respect to what's coming on the docket here for them to decide with millions of dollars up for grab. We can't have that.
Thank you. Again, this is attorney Ryan Heath, and I am getting the information. Go to the Gavel Project on Substack and also the Prescott Pulse on Substack. These things do get very in the weeds, but both of these publications, the one by Mr. Heath and also the Prescott Pulse, they have written tons of articles that really hold your hand throughout the process and explain what is going on. And I think for those of us down here in Maricopa County, we do miss throughout the rest of the state. So thank you for being so vocal. Thank you for the video that went viral of really throwing the gauntlet down. You are one the best. I do appreciate you coming and speaking with us today.
Thank you, Christy. It's been a pleasure.
All right, thank you.